Welcome to another episode of UPC Insights, where we report from the dynamic world of the Unified Patent Court proceedings. I'm your host, George Walden, and today we're exploring a particularly intricate topic, the interplay between UPC revocation actions and EPO oppositions. Joining me are three distinguished experts, Rainer Beetz, a UPC representative and Austrian patent attorney, and Sam Giles, also a UPC representative and UK patent attorney, and the legend himself, Tilman Pfrang, another UPC representative and German patent attorney. Each brings a unique perspective on how these legal processes impact patent litigation and enforcement. Today's discussion promises to shed light on the procedural tactics, national perspectives, and potential outcomes of handling cases within these two pivotal legal frameworks. So let's dive right into it and unpack the complexities of this concurrent proceedings. Thanks for joining us, guys. I really appreciate you taking the time out of all of your busy schedules to join me today on UPC Insights. We really appreciate it. Welcome.
Thank you that we can be here, George.
Thank you for the invitation.
Super. So to set the stage for our discussion, this first question is for Rainer. Rainer, could you briefly explain the purpose of UPC revocation actions and oppositions within the patent landscape? This is the second question. And why do we have these two options, distinct options available? And are there any fundamental differences between them? What do you think?
Well, examination at the patent office is not always perfect. So it may happen that relevant prior art was not known to the patent office when the patent was granted. So the purpose of revocation actions and oppositions is to invalidate patents which are wrongly granted. Revocation actions and oppositions can be initiated by any third party who believes that the patent should not have been granted due to reasons like lack of novelty or lack of inventive step.
Mm-hmm.
So what are the differences? Well, first it's the timing. So oppositions are time-bound and must be filed within a specific period after the grant of the patent, namely within 9 months after grant with the European Patent Office.
Mm-hmm.
Revocation actions, on the other hand, they can be initiated at any time during the life of the patent. And another difference is that the different forums where you litigate, oppositions are handled by the patent office who granted the patent. So in our case, the European Patent Office, whereas revocation actions are typically brought before a court such as the Unified Patent Court. And there are procedural differences. So opposition proceedings are administrative proceedings. They are more or less streamlined, focusing on the review of the patent's validity by the patent office examiners. Revocation actions, on the other hand, are judicial proceedings involving more legal procedure, more evidence presentation, and also oral hearings before the court. So what is the reason for having both options?
Mm-hmm.
Well, in theory, it's that the opposition process allows for an early correction of potential errors in the patent grants, whereas the revocation proceedings are meant for a continual oversight and correction throughout the patent's lifetime.
Okay. Well, that sounds like a lot to take in there. So that's kind of interesting. This brings me to the next point, Rainer. Are there any further options to get a European patent revoked?
Well, a further option is to file a counterclaim during infringement proceedings before the EPC, which means that you wouldn't start an isolated revocation action, but the patent holder first sues the defendant, and then in response to the filed infringement action, the defendant becomes then a claimant and files a counterclaim for revocation. This allows the alleged infringer to challenge the validity of the patent as part of their defense strategy. Additionally, with the Unified Patent Court system, there is a transitional period of 7 years, where it is also possible to file national revocation actions in individual countries. For example, in Austria, one can also initiate national revocation proceedings in parallel to opposition proceedings. And such national revocation proceedings may be of quite important strategic value from my point of view, specifically in case the European patent was opted out of the jurisdiction of the UPC because the agreement provides for that such an opt-out could be withdrawn but only as long as there's no national proceedings pending. Which means that if European patent has been opted out and you start national revocation actions, for example, in Austria, which is very, very cheap and very slow, this would be a good option to lock the patentee in the national system and to avoid enforcement within the unified patent court system.
Okay, that's interesting. Definitely Austria has a different take on things. Sam, Rainer touched on national revocation proceedings. Are such proceedings also possible in the UK? And if so, how do they operate alongside an EPO opposition?
Yes, such national revocation actions are possible in the UK. In the UK, you have the option of doing so through the UK Patent Office or through the courts. That can either be the Intellectual Property Enterprise Court or through the High Court, depending on the merits of the case and which one is more appropriate. If there is an opposition pending at the EPO, then the court has some discretion as to whether they should stay proceedings in the UK or whether not to. Effectively, when the EPC and the UK Patents Act 1977 were both put into force, there was no discussion of a stay. So it appears inherent to the system that you can deal with them both in parallel. But the default is now for there to be a stay after some relatively sticky cases about 20 years ago. But that default is fact dependent upon each and every case. So for instance, if it seems that the EPO is going to take a disproportionate amount of time to reach a first instance decision, then that may be a reason for there not to be a stay. Whilst if it seems likely that there will be damages paid by a party, but the patent may then be revoked by the EPO, that may be a reason for there not to be a stay. So it's about achieving a balance of justice between the parties. There can also be public interest in dispelling uncertainty and weighing into the balance wasted costs of having two proceedings going on at once, although this is often counterbalanced by early resolution. So in general, there would be a stay, but it depends on the specific facts, and a lot depends on the timeline and how far through the opposition we are.
How long do some of the processes take?
In Austria, usually the revocation actions usually last for in two instances, again, about 4 to 5 years. So it's a long procedure, a very slow procedure, unfortunately.
Okay, and also in the UK, is that the same?
No, we don't quite take 4 to 5 years. It's not a fast process. I'd say the quickest you could expect something would be in around 1 year.
Okay.
If it was extremely fast-tracked and it was a relatively simple case, but it wouldn't be unexpected for it to be 18 months or even 2 years.
Okay. Rainer, similar to what Sam described for the UK, how are national revocation proceedings conducted in Austria, and what differences might there be when compared with the situation in the UK, for example?
Yes, it's also possible in Austria to initiate national revocation proceedings in parallel to EPO opposition proceedings. However, we have quite a peculiar legal provision that revocation actions must be suspended ex officio if opposition proceedings before the EPO are pending or even initiated after the revocation action.
Okay.
Which means that you can start the national revocation proceedings in Austria, but as usually it's suspended directly. So the benefit of starting the both proceedings in parallel is not really given. Therefore, it happens quite rarely.
Okay. Tilman, following up on that, could you explain how national revocation proceedings are handled in Germany, and how do they interact with the EPO oppositions?
Yeah, sure. I mean, in Germany, it's a bit different compared with the UK or Austria. In Germany, national revocation proceedings are only admissible after EPO opposition proceedings are terminated or finally concluded. This is the theory, however. In practice, it's like that. You can start a revocation action in Germany, and it will continue actually. And unless at the final date of the decision, there is still the ongoing opposition proceedings, let's say your action will become admissible at that point of time or is admissible at that point of time, and there will be a final decision on the merits. This means that you can really think about the strategic option to file a revocation action in Germany in parallel to the EPO opposition, even if you know that at the time of filing the action, it is not admissible. Because it's okay for you if it becomes admissible during the proceedings. And so you can save a lot of time because we have had a short discussion on that. Revocation action proceedings in Germany take a long time.
Wow, okay. So Tilman, can you compare the UPC revocation proceedings with the national process in the UK, Austria, and Germany? And what are the notable differences and similarities, specifically when a parallel EPO opposition is pending?
Yeah, thanks. This is something maybe to wrap it up a little bit. Yeah, I would say the most the most liberal system is that of the UK, as far as I understand. You have these different options at the office or at the High Court. You can file your UPC revocation action in parallel with the opposition proceedings. You can also have decisions in both, let's say, branches of the proceedings.
Right.
Similar to Austria, the UPC may stay the proceedings in light of a parallel EPO opposition. However, Rainer explained very clearly, at the UPC, this is a maybe. It's up to the discretion of the court. And in Austria, the court must stay the proceedings. So there's a difference, I would say, to Austria. Same idea, but in effect, a bit different. In contrast, again, in Germany, it sounds a bit strange, but the revocation action at the beginning would be inadmissible. However, if at the time of the final decision, it has become admissible because the opposition division has been terminated, then everything is fine, and then you will obtain a decision on the merits. So I would say in practice, differences are not that extreme, as the procedural rules are different, but the outcome is in the different jurisdiction, maybe even similar. Maybe with the exception of Austria, where they really have to stay the proceedings, so that the decision on the merit cannot be even kind of approached.
Okay. Well, interesting. Okay, so this is going to bring us or wrap it up for the first part of the UPC revocation and EPO opposition digging deeper part 1. And I would like to thank you, our listeners, and our distinguished panel of the UPC representatives, Rainer Beetz from Austria, Sam Giles from the United Kingdom, and the Honorable Tilman Pfrang from Germany. All of us at the UPC Insights are really happy that you all took the time out from your busy schedules to talk with us today. And we would like to share a lot of stuff with you in the future. We have a lot of great UPC Insight content from past shows that are more relevant and exciting than ever. And we urge you to check them out on our YouTube channel or our website at meisterbolte.de or at meisterbolte.com. If you have any questions or any UPC Insight topics that you would like us to talk about or explore, feel free to contact us. Until next time, see you soon on Auf Wiedersehen.